Your Honor, as part of housekeeping, and we do not intend to get into the nerves of the court, this is a very special occasion. And we were told, and I think this is the practice in Commonwealth, that court appearance is more than a ceremony. Your Honor, would you be able to give guidance to the accused persons that they should not be seen to be like they are masked deliberately to hide their identity? Because it can't be by coincidence that all of them have viral or fungal diseases. Would there be some neatness in the way the accused persons appear? They are officers of KWS. What is the problem in unmasking? We also want to see them. This is a public court. These are open proceedings. What are they hiding?
Your Honor, I don't see any prejudice to my clients having their masks on. Court has in recent and past times proceeded with accused persons.
I do not wish to even make a determination. Just remove your mask.
Very well.
Let us talk that.
Very well, Your Honor.
For purpose of this court, I do not entertain cheering or even clapping. Yes. Let's keep the same. Very well. This is the ruling. Early this afternoon, 6 persons were brought before me. Where are they? They are all present. Francis, Kochiro, Alexander?
Yes, sir.
Aisa Kochian?
Yes, sir.
Aisa Kochian.
Yes, sir.
You see, you are masked. I only get to hear the sound, you're not? Aisa Kochian,
Yes, sir.
Michael? Michael?
Yes, sir.
Yes, come next. Evans Kimayo?
Yes, sir.
Yes, come next. Then Abdul Rahman Ali Sudi. Yes, early this afternoon, 6 persons were brought before me to take plea. They are Francis Wachira Kashoki, Alexander Lorogoi, Isaac Ochieng Odhiambo, Michael Abukala, Evans Kimayo, and Abdul Rahman Ali Sudi. Before plea was taken, an issue was raised by Mr. Abuya, Mr. Kipkoech, and Mr. Wanjir, appearing as watching plea for the complainants, the Law Society of Kenya, Vocal Africa, and IMLU. The issue revolved on Mr. Leon Callisto's representation of the persons charged. They jointly pointed out that Mr. Leon Callisto is the legal officer employed by the Kenya Wildlife Services, which I'll be describing as KWS for purpose of this ruling. They submitted that the said counsel cannot represent the accused person on the following grounds. 1, that criminal culpability attaches in persona, hence not institutional. That the offense is against the accused persons and not KWS. 2, that Mr. Callisto is conflicted by dint of drawing salary from the government, hence cannot represent individuals at trial. 3, that Mr. Callisto can only represent the accused person if the offense was sanctioned by KWS. 4, that the case has nothing to do with KWS as an institution, but against the 6 individuals. And finally, that allowing Mr. Callisto to represent the accused persons would reduce the case to ODPP versus KWS. Mr. Callisto submitted in response that the accused persons are officers of KWS and that being the institutional lawyer has a duty to represent the accused person. He submitted further that he holds a valid practicing certificate. He stated further that the alleged offense was committed while the persons charged were discharging their duties as officers of KWS, hence KWS has the institutional responsibility of representing the accused persons. He stated that this is not an isolated case as he represents the institution in other similar cases. He submitted that the institution did not see the need to outsource legal services for the accused, hence opted to utilize the internal lawyers and for this case himself. Article 52G and H, to which the application subject of this ruling dangles, provides as follows. Every accused person has a right to a fair trial, which includes the right, G, to choose and be represented by an advocate and be informed of this right promptly. H, to have an advocate assigned to the accused person by the state and at state expense if substantial injustice would otherwise result, and to be informed of this right promptly. All submissions presented both for and against are in agreement with this constitutional provision as outlined above. The departure, however, in this case is representation by Mr. Callisto, the legal officer of KWS. To put things straight is that it is not in doubt that Mr. Callisto is an advocate of the High Court of Kenya and also a valid practicing certificate and qualified to practice before this court. According to Mr. Callisto, and also not in contest, is that for purpose of this case, he draws his instruction from KWS, who doubles up as the employer of the accused persons in this case. The council's watching brief holds the view that criminal culpability attaches individually. Therefore, the institution, and in this case KWS, has no business seconding a counsel to represent the accused persons. For clarity of record, the prosecution opted to stay away from the present contents, hence did not make any submissions. I agree with the council's watching brief that criminal culpability attaches in persona. The person sued or charged bears individual responsibility of crime and is sanctioned or punished in person. KWS, as submitted by Mr. Callisto, held the view that since the offense was alleged to have been committed by the accused persons in the course of executing their duties, then they have a duty to defend them by seconding their counsel. The relationship between the individuals charged and KWS as an institution is not in doubt. From the submissions of Mr. Callisto, KWS does not seem to believe in the charges, hence instructed their counsel rather than outsourcing. I do not, with respect, see anything wrong with this arrangement. Even assuming that the accused are found culpable in the end and a recourse is pursued by the complainant, the recourse would, by dint of the relationship established, lie on the institution. Hence, they have a right to protect their institutional interest from the fall. My other question then would be, will Mr. Callisto's representation of the accused in any way occasion prejudice? None has been submitted before me. Nothing has been laid before me demonstrative of any prejudice. As I conclude, an issue was raised that Mr. Callisto is conflicted to the extent that he draws his salary by representing accused person in their individual capacity. This position takes me to the middle of this ruling on the interest of KWS in this case. Other than defending the individuals who are employees of KWS, KWS is protecting its institutional interest. I do not, in the premise, deduce any conflict. The Constitution, as pointed out, and as lifted above, only makes reference to right to representation by another, further to state that an accused may be represented by an advocate at the state's expense. There therefore lies no conflict. In the end, I do find that Mr. Callisto is within his right in representing the accused person's hearing. He is permitted as such. Those are the orders of this court.
We are very much obliged, Your Honor. We are now ready to take plea on behalf of the victims and the complainants. Your Honor, as part of housekeeping, and we do not intend to get into the nerves of the court, this is a very special occasion. And we were told, and I think this is the practice in Commonwealth, that court appearance is more than a ceremony. Your Honor, would you be able to give guidance to the accused persons that they should not be seen to be like they are masked deliberately to hide their identity? Because it can't be by coincidence that all of them have viral or fungal diseases. Would there be some neatness in the way the accused persons appear? They are officers of KWS. What is the problem in unmasking? We also want to see them. This is a public court. These are open proceedings. What are they hiding?
Your Honor, I don't see any prejudice to my clients having their masks on. Court has in recent and past times proceeded with accused persons.
I do not wish to even make a determination. Just remove the mask.
Very well.
Let us talk that.
Very well, Your Honor.
For purpose of this court, I do not entertain cheering or even clapping. Yes? Let's keep the silence as required. Yes, read the chat. Which language? Yes, yes. Francis, which language?
Alexander? Aisa? Mshtakiwa na kosa ya kuteka nyara kwa nia ya kufungia kinyume cha sheria kwamba tarehe 18 mwezi wa Januari mwaka huu mwezi wa 2015 katika Kondeni area na East Sub-County na Nakuru County kwa pamoja na wengine ambao waweza kufikishwa hapa kotini waliteka nyara Ryan Odhiambo mkiwa na nia mkiwa na nia na kwa ubaya kumfungia mahali pasipojulikana. Ni kweli ama si kweli? Francis?
Si kweli.
Alexander?
Si kweli.
Isaac?
Si kweli.
Michael?
Si kweli.
Evans? Abdulrahman?
Si kweli.
Yes, we have no guilt recorded for all the accused persons.
The affidavit is to the effect that in the event my clients are released on cash bail, there is a likelihood of interference with the witnesses. Your Honor, from a cursory perusal of this affidavit, court will note that these are mere averments. They are not substantiated. There is no any tangible, real, actual evidence that has been placed before court to support the averments that my clients will interfere with the witnesses. They have stated in the affidavit that they reported the incident of interference to the DCI. Unfortunately, no OB has been attached to this affidavit to confirm those averments. He who alleges must prove. They have failed to do so. In the circumstances, Your Honor, there are no compelling reasons as provided for in the bond and bail guidelines or section 123A of the Criminal Procedure Code. And in the circumstances, Your Honor, I pray that my clients be granted reasonable bail and or bond terms, they will at all material times, when and as required by court, avail themselves in the circumstances. I pray that a reasonable bail be granted to my clients. That's all.
Yes. Your Honor, on behalf of the prosecution, with respect to bond, we are praying that bond be suspended at this point for the following reasons. When we were earlier in court today, before we took a break, we were served by Mr. Abuya an affidavit by one Elizabeth Auma, who is the mother to Brian. The affidavit is dated the 5th of May 2025. The affidavit there has raised serious allegations of possible witness interference. Your Honor, the law requires, before bond is given, the law requires that, or denied, the law requires that we demonstrate compelling reasons in oppositions of bond. Your Honor, the allegations of possible witness interference have not been formally reported to the station. The investigating officer has been informed today. No investigations of the averment contained in the affidavit have been undertaken. Considering the averments therein are grave and will touch on whether the accused persons are denied bond, we propose that the same be subjected to investigations and we be given time for the IO to undertake that. We also propose that a mentioned date be given during which we shall present our substantive position on the issue of bail or bond. We're also proposing that prebail report, the court calls for a prebail report in the meantime. We're proposing 7 days.
The case is now in the hands of the state prosecutor. If they have any issues that they feel they can address to you, they can always channel them to you. Yes, no. Yes, Your Honor. Yes, Your Honor. Yes, Your Honor. Very well, very well.
Your Honor, very briefly on behalf of the interested parties that we represent and the victims, on the basis of the affidavit dated 5th of May 2025, the bond 2 by Madam Elizabeth Auma Ogega, this is the mother to Brian Odhiambo, we oppose bond for the reasons stated therein. Your Honor, I would give Mr. Abuya a few minutes after I'm done to give a brief highlight together with Mr. Wanjiru. In other terminology, Your Honor, we rely on Article 41H of the Constitution of Kenya. 49(1)H of the Constitution of Kenya, which allows all accused persons bond, reasonable terms, where there are no compelling reasons to deny bond. So that, Your Honor, whereas the right to bond is a constitutional right and rightfully submitted to by my learned friend, it is qualified. Your Honor, in perspective, this is a very serious offense. Abduction, this is an allegation as it is at the moment, but it's too serious because it has been investigated. The Director of Public Prosecution under Article 157 is persuaded that an offense has been committed. This is abduction by security apparatus of the country. People who are armed, people granted weapons, arsenals of death for purposes of securing the country. But a person disappears in their hands. And to make it very sad, Your Honor, this person has not been found. The mother is here crying. The wife is here mourning. The family, the community, and all defenders of the rule of law. This is a compelling reason why the suspects, the accused persons herein, should not be released until, at the very least, the mother, the wife, and closer family members have given evidence so that their security, their safety, and the integrity of these proceedings are protected. Your Honor, I would refer you very quickly to two decisions, reported decisions of the High Court and the Supreme Court. Your Honor, in the Supreme Court case of Waitito versus Republic, this is reported in 2021 Kenya Law Reports, electronic. The Supreme Court, given an opportunity to review the decision of the Court of Appeal, Your Honor, to grant, to deny, or to qualify bond terms at paragraph 77, said the appellant has not demonstrated how the exercise of discretion was not judicious and how the learned judges of the High Court and the Court of Appeal erred in failing to interfere with the exercise of the trial court's discretion. Consequently, we do not find any reason to interfere with the Court of Appeal findings. This is a very studious court. I will not belabor to rehash these findings. What is very relevant, Your Honor, is paragraph 64, where the trial court, like this court, looked at Article 49(1)(h) of the Constitution of Kenya and restricted this constitutional right of the accused persons. This is such a case. You are facing officers from the security apparatus, people well trained, using enormous resources to protect lives and secure a country. But in the long run, a poor citizenry disappears in their hands, to date, within their custody, within a national park. There is every likelihood, Your Honor, that they would interfere with not just the witnesses, but also with the integrity of these proceedings. And this is deponed to by Elizabeth. Your Honor, Kenya, under Article 2.5 of the Constitution, has adopted, and this is a very progressive court, international conventions, international treaties and conventions, so as to become part of the Kenyan law. International Convention on Civil and Political Rights is part of the jus cogens of our law. It prohibits, Your Honor, abduction. Kenya is party to the Rome Statute. Abduction by state security apparatus is an international crime. It's a very serious crime. And that is why we are urging you, Your Honor, to find that this is not an ordinary offense. This is not an offense where the suspect is an ordinary person. These are officers, paramilitary officers, trained superiorly. They get hold of a person, a poor person, who evaporates in their hands. As deponed in the affidavit, so much more could happen to these proceedings, to the witnesses, and we urge you, Your Honor, to find that there is a compelling reason not to release the accused persons on bond until, Your Honor, the witnesses that have been mentioned by Elizabeth have given evidence. I know at this juncture, you are not determining the case on the basis of